at this point to make a comment, but I'm not opposing the amendment. And whilst I don't oppose the amendment, I have to reiterate that I still foresee constitutional difficulties with the private member's bill. The private member's bill differs from that being prepared by my department. It does not differentiate between prospective and retrospective adoptions. In that respect, it does not address the complex constitutional issues that arise in relation to the provision of identifying information to those and about those who were adopted in the past. The legal advice that I have received indicates that a right to know one's identity flows from the legal relationship between a birth mother and her child. However, the effect of an adoption order is to restrict that right to know. And while I'm in favour of providing an adopted person with as much information as possible about their identity, there is a difficulty surrounding the notion that a birth mother's constitutional right to privacy can be dispensed with or retrospectively changed by new legislation. As the Senators are aware, my department is developing the heads of the Adoption Information and Tracing Bill, and work on the heads of that bill is nearing completion. It will set out the information to be provided and the circumstances in which it can be provided for past and future adoptions. The bill will be explicit on the information that must be provided for all future adoptions. All who consent to an adoption will be fully aware of the information that will be available to an adopted person on request once they reach 18 years of age. In regard to adoptions that have taken place in the past, the issue is far more complex. I am advised that the proposed legislation can provide for retrospective identifying information to be given to an adopted person, but some restrictions must apply in relation to birth mothers who wish to protect their right to privacy. I'd be concerned that the private member's bill doesn't fully address these constitutional issues. But as I say, I'm not opposing this amendment.
Thank you. Minister, as we outlined at second stage, we appreciate that there are two rights at play here. There's the adoptee's right to their identity and the natural parent's right to privacy. The courts have made it clear that neither of those rights are absolute. In the IOT and B case, that point was made. It has been made. It's consistently made in constitutional cases with respect to all of the rights in the Irish Constitution. There's not a single right in the Irish Constitution that is absolute. All of them must be balanced against competing rights within our constitutional framework. The courts have also made it clear that the job of seeking to achieve a workable balance between competing constitutional rights is that for the Oireachtas. And the Supreme Court, dear students, makes it very clear that it's only when the court, a case has to be brought in the first instance, and it's only if the court is of the view that the Oireachtas has made a complete mess and has got the balance completely wrong, that they will interfere. In fact, many legal commentators would say that our Constitutional Court, the Supreme Court, is too deferential to the Oireachtas. But under our system, the separation of powers makes it very, very clear that it's the Oireachtas, the job of the Oireachtas to legislate. Any act on leaving these houses and on being signed by the President immediately enjoys the presumption of constitutionality. That is then only challenged if somebody brings a case, if the President refers in Article 26, references the Supreme Court to test the constitutionality of a bill, or if an individual brings a case challenging it. But this legislation, when it passes through both houses of the Oireachtas, as I hope it will with your cooperation, will benefit from the presumption of constitutionality. We are, I'm confident that it's constitutionally sound. We have got extensive legal advice on this. Dr. Fergus Ryan, who drafted the bill for us, is a constitutional law expert. I have consulted with other constitutional law experts who are also of the view that the bill is constitutional. Of course, Minister, these issues are arguable. That's always the situation until the Supreme Court hears a case on an individual piece of legislation. Nobody can say that with certainty that they would or would not uphold the bill. You only know that when the court actually considers the case. But I think the arguments that it is constitutional are persuasive. We very carefully balance the two rights. In fact, it's arguable, Minister, that the current situation is completely unconstitutional because in elevating the privacy rights of the natural parent, we have completely nullified any right to an identity. So the current balance if you can even call it that, which we have between privacy and identity, says that in order to protect the privacy rights of some women who may wish to exert privacy, and let's be very clear, that's not all of them, that in order to protect privacy rights of some women for whom this might be an issue, we're prepared to completely ignore and give no value whatsoever to the identity rights of 50, 60, 70,000 Irish adoptees. That's not a balance, and that's not correct. Our bill balances the two rights in a way that we believe is fair. It makes a distinction between the adoptee's right to identity and to have identifying information about themselves and their family background, and contact, which we accept is a different issue. And under the bill, it makes it very clear that the adoptive parents' contact only be released if they're happy for those details to be released. So we think that's a fair system. It also puts in place an intermediary arrangement through which adoptees and natural parents may have contact with each other, and the natural parent, if they're seeking to have to reach out to their adopted son or daughter, can go through the adoption authority and do that, and vice versa, where an adoptee wishes to make contact with their natural parent. I mean, let's be very clear, Minister, the current arrangement does not prevent unwanted contact. If anything, it actually makes it much more likely, because even without a statutory right to your birth cert and the ability to get this information straight away as a matter of right from the adoption authority, adoptees can go and get the information themselves. They can do their own trace. There's quite detailed guidelines that have been produced by the Adoption Rights Alliance and others to assist people in doing a trace. As I said, the birth records are public documents. If you can narrow it down to a name or even just a year, if an adoptee goes in and looks at their birth date, they can ascertain straight away from the public records the name of every, say, girl, if you're a lady trying to do a trace, of every female baby born on that date. You can then get the names of all of the parents, of all the natural mothers, usually the only name on the birth cert. You can then narrow that down using other information. You're able to ascertain things like geography, and particularly, as I said, if there's an unusual name, quite quickly then you can go from having a name on the birth cert to ascertaining somebody's address. You can go on to the electoral register. For the country, most of the electoral registers are now online. The electoral registers, I was looking at them again myself last week, the Dublin City Electoral Register, you can go on and look at from the comfort of your home on your laptop and get the home address. If you have somebody's name, you can go and get their home address of where they lived in the mid-60s straight away from the electoral registers, because those documents are public. So it takes a lot of effort, and it's very disheartening for people to have to go and do that on their own, and it's a lonely journey. But it's not impossible, and people do it. And when they get to the end of the road and they have the information, because there's no intermediary for them to go through, their only option is to make direct contact with the natural parent concerned, or vice versa if it's a natural parent tracing their adopted adult son or daughter. Nobody wants to do that, Minister. That's not a supportive situation for anybody. I know, as an adopted person myself, when I reunited with my mother, I was so conscious of being sensitive to her needs and not knowing the circumstances of my birth or how difficult that may have been for her, how difficult the adoption was. We would all prefer to have a system that's supportive for everybody concerned, and has an intermediary, rather than putting people in the situation where they have to write letters out of the blue, or make phone calls or turn up on somebody's door. Nobody wants to do that. So the current arrangements do not prevent unwanted contact. And in fact, the arrangements that we are proposing would deal with that issue. But it is important to distinguish, as the bill does, between access to identifying information and contact. Not every adoptee wishes to have contact, wishes to re-establish a relationship with their parents. Some do, some don't. Some simply want to know who they are. They want their own records if they spend time in a mother and baby home. They want to know if they were subject to vaccine trials. They want the rest of their medical history. They don't all necessarily wish to meet. And as I said, those who do, I think, handle it in a very sensitive way. But I think our whole approach to this area has been based on this false assumption that adoptees are these irrational, insensitive people who are going to force themselves into the lives and homes of their natural parents. I think that's incredibly offensive. I think it's really, really unfair. It's not true. And if that is the situation in a tiny minority of cases, and as I said, that's completely possible under our current arrangements anyway, that people can do that if they wish. We have other laws to deal with that. We have laws on harassment and things like that, which are completely separate. But I think to assume that the worst case scenario and legislate for the worst case scenario is incredibly unfair. It has done a great disservice to thousands of adoptees and their natural parents. It has also done a huge disservice to the women involved, and I know that I've had so much correspondence, as I know Senators Van Turnout and Healy Eames have, on this issue from natural mothers since I first started talking about this. And many of them would tell me they're far from seeking confidentiality. They were forced to sign agreements. They were forced to swear oaths by clergy. Their baby was taken from them in the hospital just after they gave birth when they weren't in a fit state of mind. They were bullied into putting their child up for adoption. They were bullied into signing forms. I have yet to see, and I've yet to, Minister, I would love you to produce it, or Adoption Authority or anybody else, a confidentiality agreement that was actually sought by a natural mother. Because my understanding was that it worked the other way around. The women were forced to sign papers. They were forced to swear oaths saying they would never look for their child. Many of those women have carried the hurt and the pain of that for years. Last time we brought forward this bill, Philomena Lee issued a plea to Minister and to the government to accept it. And she said that if this bill had been in place when she went looking for her son Anthony, and indeed when Anthony was looking for her, she would have met him before he died. And she didn't, precisely because of all the secrecy and the assumption that women don't want to be reunited with their children when that is not the case. We accept, of course, that there will be some cases in which some women may not wish to do that. They may find it difficult. The circumstances of the birth may have been difficult for them. They may not be in a place yet where they're ready to deal with it. But we also think that at least by the Adoption Authority reaching out to them and making them aware of the fact that their son or daughter is looking for them and offering them counselling, that it will actually offer those women space to think about it and to talk about it. And for some of them, maybe the first time they've talked to anybody in years. I've had women come to me and tell me that they haven't had that since a lady told me that she's in her 70s, she gave her child up for adoption 40 years ago and she's never had a conversation with anybody about it. She broke down telling me what had happened. And I think there are a lot of women like that out there. I've also had contact from women who've said that they stayed silent for so long because they were worried that their spouses wouldn't be happy or that their sons or daughters would be annoyed that they had this act, that they had a son or daughter before they were married and they hadn't told anybody. And all of those women have told me that when they actually reached out and when they told their family about the child that they had put up for adoption, their reaction from their sons, their daughters, their spouse was, why didn't you tell me this before? You know, adults you're dealing with, for a lot of the women, I think they're trapped in pain from 40s, 50s, 60s and how we treated women then and the judgmental attitude that we had towards women then. But they find that actually when they tell their adult sons and daughters about their adopted child, that the sons and daughters just say, my God, you're my mother. I can't believe you've been carrying this pain. Let me help you. And actually the sons and daughters are the ones who help them then to get through it and look after their mother in re-establishing a relationship with their adopted child. So I think, Minister, it's not right that because of some obsessive and irrational fear of the worst case scenario that we do nothing for 50, 60,000 adopted people and their natural parents. It's based on false assumptions, as I said, that the women don't want to be contacted, which is not the case. In many circumstances, many of them have bet paths back to the mother and baby homes. Sean Ross Abbey in Philomena's case, the same with other women who have gone back to the orders looking for information and been denied it. And they are equally, as much as their adopted sons and daughters, are equally looking for this legislation and asking you to work with us on bringing it forward. I note that you mentioned that you're still working on the government's adoption information and tracing legislation. I have to say, Minister, I find that disappointing because you have a bill here that has the support of the House, that at second stage received the overwhelming support, and I thank them for that. of the Fine Gael and Labour spokespersons. We acknowledge that it's not perfect, Minister, and we would like to work with you, and we hope that at report stage you will bring forward amendments to address any of the concerns that you have. But we have a bill. The government doesn't even have heads of a bill, and there's only a year to go. These women can't wait any longer, Minister. I'm constantly contacted by people that tell me that by the time they finally got to getting the information that they needed, the person they were looking for, whether that was their mother or their sibling, had passed away. We have an opportunity here to do something, and we would really hope that you would work with us on doing that. We accept that there's a constitutional context. We have put an awful lot of work into making sure the bill is constitutionally sound, but we are more than willing outside of the House to sit down with you and discuss that, to bring our legal experts to sit down with yours to trash this out. But, Minister, we have to find a way of moving this forward. The excuses about why it's difficult just aren't enough. And if the government is intending to bring forward a bill that takes the easy option of just saying that you're going to legislate for open adoption going forward, that doesn't help anybody. There were 112 adoptions last year in Ireland. 112. There are 60,000 people like me who were adopted in the past who don't have any right to their information. And if you bring forward a bill that just does something for people going forward, you're doing an incredible disservice, and it's really unfair to everybody who was adopted before that. I appreciate that it's a sensitive issue. I appreciate that it has to be carefully addressed, but we are prepared to do that with you. Other countries have legislated. The UK have had a system for 40 years where adoptees are entitled to the rights that we're providing for in this bill. So there is precedent there. It is workable, but we need you to cooperate with us in helping to move this bill forward.